Article 19 is the grievance procedure. It's the path that fixes a problem at work, and it runs on deadlines. Miss one, and a good grievance can die on a technicality. Here's the order and the clock. The clock starts the moment you, or your representative, could reasonably have known about the incident. From there you have 30 days to bring the complaint to your supervisor and try to settle it in conversation. If that discussion doesn't solve it, the grievance goes in writing, signed, to your supervisor within 10 calendar days of the discussion. Your supervisor then has 10 calendar days from receiving it to answer you in writing. Not satisfied? You or your union representative appeal to the managing director within 10 calendar days of that written decision. They meet to hear it within 10 calendar days and rule in writing within 10 days of your presentation. After that written decision, there are 14 calendar days to take it to the System Board of Adjustment. Note who files it: the union, by serving written notice on the Vice President of Maintenance. This comes before any of that. If the company questions you about an incident that could lead to discipline, they have to tell you first that you can have a union representative there. Refuse it, and they must document that refusal and have you sign. For a non-probationary employee, discipline to the extent of lost pay can't be imposed until a fact-finding meeting is held with your supervisor and your chief steward. And if a suspension pending investigation is later found to be without just cause, you're paid for the lost time. The board is 2 members named by the company and 2 named by the union. On a discharge or a suspension that cost you pay, it convenes within 30 calendar days of the appeal and decides no later than 30 calendar days after the record closes. Deadlines cut both ways. If the company misses a time limit, your grievance is automatically appealed to the next step. But a company answer the union doesn't appeal in writing within 20 days is considered closed. You don't go in blind. On request, the union gets access to the documents the action was based on, and both sides disclose their data and witness names at least 15 calendar days before the board or arbitration. Late material, no less than 48 hours out. 2 last things. The union can file a group grievance when the issue is common and identical across a group. And probationary employees aren't entitled to grieve discipline or discharge at all. Every time limit here is a maximum, so bring it to your steward early.